good morning, everyone. Wednesday, 10 a.m. Mountain Daylight Time. It's actually 10:11, and we're back with another episode of the Canadian Immigration Live Q&A, and I'm very happy to be back. It's been a while. Today it's just Alicia and I, so how are you doing, Alicia?
Oh, I'm good, Igor. Igor and I both live in Calgary, and I don't know about you, Igor, but it's like a snow globe out there. Like I went out to
Really?
shovel, and by the time I turned around, I had to redo the whole thing, and then I had to come in.
Are you serious? Like, we
Oh
have
yeah.
not a single snowflake in Legacy. That's
Oh my gosh.
crazy.
So Igor and I are like 45 minutes away. I'm on one side of the city and he's on the other, and it's dumping here. Like I can't even see outside. So,
Wow. I mean, sometimes I forget like how big Calgary is. It's like what, like 60 kilometers like from one end to another, and it takes like forever to travel. Like you need to full tank to go around the whole town. Um, so yeah, like if we have hailstorm in one part of the city, then it may be sunny and warm in the other part of the city. So um, it's just so big that it's impossible to predict the weather for the whole town.
yeah, yeah.
All
Oh,
right.
well, a few immigration updates. I know there's been talk about Bill C-12, so I was reading about what's been going on with the Senate recommendations, and there's some definite disappointment about the privacy implications that that could have, and the fact that the government is proceeding without the Senate recommendations on changes to the bill. So it looks like the only thing that they are going to actually change will be a review of the bill in 5 years. So.
Oh, well, and Alicia, for those of our viewers who don't know what Bill C-12 is, can you remind them what it's all about?
Mhm. Yeah, so it's a large omnibus bill that is going to, among other things, have serious implications for immigration, citizenship, refugees, Canada. And one of the most contentious parts of this bill will be giving the federal government immigration department sweeping powers with respect to changing and removing people in an expedited fashion if they have made a refugee claim and they have been in Canada for more than a year, and it's going to go back to retroactively to June of 2020. So that's causing a lot of concern, basically prohibiting people who've been here for a year since June of 2020 from making a new refugee claim, but also other powers in terms of being able to potentially cancel whole streams of applications. And also what I was talking about earlier about sharing information, privacy, sharing legislation between provinces and also potentially outside of the government of Canada with respect to who is a temporary resident and who is not born in Canada.
Yeah, and well, many people fear that the government may cancel the whole class of applications. So, for example, agencies, TRPs, I'm not sure, but do you think what categories of immigration applications are at most risk?
Yeah, and of course, this is all speculation because we just don't know what they will do. It's just that they are being given these powers. But for sure, immigration is taking a look at a giant backlog, just like you mentioned, in humanitarian and compassionate applications. So if we look at the levels plan for how many agency applications the government has planned to process in 2026, 1,000. That's it. 1,000. And if you look at the processing times right now for an agency, it'll give you the backlog information, and processing times are upwards of 10 to maybe 50 years. So that's definitely one that we worry about. The other one that we worry about would be the startup visa program. So that one has massive backlogs and delays as well. They shut down the program. They're not taking new applications. Though it's interesting, Igor, because there was the updated immigration departmental plan. And so maybe we can pull that up. I'll see if I can get this in for you. But basically, they they made mention of a couple interesting things in that departmental plan. And one of them was possibly bringing back a new startup visa program that corrects all the errors. So, you know, we'll see. Um, I'm just sending you the link, Igor, in email. And if you want to bring up that new departmental plan, they did release that, I think March 13th was when they released the departmental updates. And there are some interesting nuggets in there with respect to temporary residents and with respect to permanent residents. And so there's been some speculation in there about what they might be changing. So if we take a look, I don't know, Igor, if you are able to find it, yeah, and then pull it up. And so basically it's talking about what their indicators are going to be in terms of the targets and what they're assessing themselves against in terms of have they met their targets. And many of these targets are processing targets or making sure that people are not claiming asylum targets. So that's kind of what the first part of the departmental plan is talking about. And then in terms of how they are going to achieve these results, if you expand under DR1 there, they're really talking about maintaining the levels plan with respect to sustainable numbers of temporary residents and temporary foreign workers. They are looking at effectively calibrating visa requirements to maximize economic benefits without undermining security. Strengthening program integrity. So they more more indications that they're going to continue with liaising with the designated learning institution for students and checking up to make sure. This was one of the things Minister Diab was in the news about, getting questioned about whether IRCC is following up with students and the schools to make sure that they were actually attending the institutions and achieving passing grades in their classes. And so that's become an issue with making sure on the back end that IRCC is double checking for fraud or for people who are no longer meeting study permit conditions. And then if we take a look at the talent attraction strategy, there are some interesting labor mobility pathways to attract business persons and highly skilled workers to drive economic growth. So they're looking at that. Maybe processing study permits for doctoral students and global skills strategy on a priority basis. So keep in mind that this departmental strategy is for 2 years from 2026 to 2027. So, there's no indication of when exactly these will happen. So exempting master's and doctoral students who are enrolling at public DLIs from the PAL requirements, which would really facilitate people who are looking at trying to get that study permit because right now they're capped with the provincial attestation letters. Stuff with global talent stream, collaborating with major projects office and ESDC to develop a streamlined approach to facilitate the recruitment of international workers to support projects of national interest. So this is interesting. They haven't given us more details about that. Evaluating outcomes for PGWP, Francophone communities. And then if you go down into the other changes in core responsibilities, it does also talk about potential changes to DR2. So what they're doing, if you keep scrolling down, is what are they doing in terms of permanent residency? And so this is where anybody who follows us who's interested in express entry will want to listen because this is where they are talking about various targets, so family reunification, but also express entry. And then also you'll see there's reference to a new high impact startup visa pilot that will replace and address observed issues with the existing startup visa program. So yeah, so this is interesting. We'll see what happens with that. They want to reduce the inventory of protected persons. They want to strengthen asylum. They want to make sure that they are processing applications. You can still see that French target. So achieving that French-speaking PR admissions target of 9% in 2026, which is going to increase to 12% in 2029. So if you keep scrolling down, Igor, it's a little bit further down there. So this is really interesting, and there seems to be no let up in French, right? So the continuation of French. And there is something in here, and I can't remember where it is now, but it should be in here. I might have just skipped over it. But they were looking at potentially bringing back points for job offers again.
Oh.
And so they have not given us, yeah, here we go, broader suite of reforms, including the addition of points for job offers and Canadian work experience in high wage occupations, and consideration of how to reward those in who are certified to work in regulated occupations. So I'm not sure about, I think there's a couple typos in there, but looking at maybe bringing back points for job offers. So if you have Canadian work experience, high wage occupations, so I guess this does not apply for low wage occupations. They're not saying low skilled, of course, because low skilled is not eligible for express entry, but also, what's going to be high wage? Probably they're going to be looking at ESDC and what we already have set up for LMIA determinations. But if they're bringing back job offer points and it's going to be tied to high wage with Canadian experience, that's something people should plan for. And then they're also looking about regulated occupations. And regulated occupations can be a whole can of worms. Mark and I did a podcast on certificates of qualification under express entry and what counts. So go take a look at that because definitely regulated occupations can become complex.
Hmm. And I'm thinking about those job offers, Alicia, and um, like this thread leads me to thinking about LMIAs and how
Hmm.
people would often get confused with the term of job offer. What is a job offer? And so,
Yeah.
um, for those who are new to the channel and who just learning about express entry, in the past you would be given 100 or 50 points for the job offer if you had an LMIA supported job offer. So your employer needed to get an LMIA and then would give you a job offer. Without the LMIA, the job offer is essentially it's like it doesn't matter. And so now I'm seeing another problem, right, Alicia, that we're dealing with and getting LMIAs, which is another point of discussion, and it's just it's painful. Our Monday
Well,
wasn't really pleasant from the very start because we're working with one of the clients on an LMIA application, and it seems that the process is just designed to be, you know, how would I say it? Non-functional,
broken.
broken. Yeah.
Yep.
Um, Maybe you can share more details about that, Alicia. Like, what do you see on the ground?
Yeah, and just to circle back, Igor, for the job offer points, take a read of my blog article. So it's called Can I Claim Job Offer in My Express Entry Application? I updated this post last March when they took away the job offer points, and job offers are still important depending on whether you're eligible under FSW and whether you have to meet arranged employment points. And job offers might be important now if they bring back those job offer points. So Igor's right, you usually need to have an LMIA, but there are some circumstances where you could claim job offer points if you are on a closed work permit, so employer specific work permit that is has been approved and you have already worked for that employer in that closed work permit for a year in Canada. So that's, you got to be careful about when you are claiming job offer or arranged employment points, but take a read of this and it might be worth it. Most people have just been skipping over this section in their current express entry profiles because they took away the points. But if they suddenly bring back points, you might want to go in and double check what you've written in your profile for this section, because once you do hit a year on a closed work permit, if you can get a letter from your employer and they agree that they will continue to employ you for a year after PR,
Hmm.
then you might very well be in a better position if all of a sudden they change their points determination. So,
Yep.
but circling back to LMIAs, LMIAs are a giant headache. ESDC has had known issues for a few months with respect to the online LMIA process. And so, for those of you who don't know, LMIAs used to be paper applications, used to literally submit an application, this big form 5802, and basically now it's all online. And so there's an LMIA process online, and most people have to submit a transition plan. And that transition plan has screens where you have drop down sections for 4 different activities. And ESDC has had errors internally, so glitches with their system. As soon as you close your application or reopen your application, or if you time out of your application, guess what? you can never finish your transition plan correctly. So we tried everything we could think of. We put an error report in. We took screenshots of every single subsection in the transition plan because we did put them in there. They were saved. It's just that it showed as pending when you go back to the main screen. So we submitted this LMIA, and then with the error report, and ESDC came back and they said, oh yeah, we know about that issue. The way to fix it is you can only do one session. So this is like a 30-page application with multiple drop-down fields. You cannot time out. There cannot be a glitch. You just have to do all of your entries in one session and then submit it, and it won't have that error code on or the pending on the transition plan. We did all that. Then they sent a payment request. They said they were going to close the first file. They didn't close the first file. The payment request was only on the first erroneous application. They never sent a payment request on the second application. And then guess what? They closed the file saying there was no payment received on the second application. Like it's bonkers. It's not working. It's super frustrating for us, for the employers, for the employees, for everybody involved. And I really hope that they fix their processes soon.
Yeah, or at least they let us know that, okay, this is an issue that we know about for the last 3 months, and here's how
Yeah.
to get it, like, get past this error message or this
Yeah.
pending status for your transition plan. Like, if it's a known
Yeah.
issue, why it's not
Mm-hmm.
publicly communicated? And
Yep.
um, I just cannot, like, there is a question, thank you for highlighting on LMIA. Under the current scenario, what is the percentage of LMIA being approved or issued? I would say the percentage of refused LMA probably is skyrocketing because people they just maybe they think that's exactly how things supposed to be. Like the transition plan would show as pending, and then all of a sudden their application is refused. So those
And
technicalities
and
they allow to refuse so many applications, and we just never know how many of them are not even taken into processing.
and that's just it, Igor. They're not even refused. They're just rejected as incomplete.
Mm-hmm.
And so ESDC keeps track of refused applications, but they don't normally publicly release the figure of rejected as incomplete applications.
Mm-hmm.
And if the reason that 90% of your applications are rejected as incomplete is because of your own technical errors through the
Exactly.
government, that's not fair.
Yeah, and like on the listserv where other immigration lawyers just share their experiences, I just see that people share, that ESDC sometimes is asking for requirements that are not even in the RCC instructions. Like, why you didn't offer job to other people on work permits in Canada? Well, that's the whole point of the labor market impact assessment to assess whether it will impact Canadian citizens or permanent residents. And
Yeah.
like you need to first try to find those for the job, and then that's why like you get an LMIA so that you can hire temporary foreign workers. So
Yeah.
there are a ton of challenges with the LMIA process, and I think that's is another episode for the Canadian Immigration Podcast where this can be discussed in more detail. And I'm also thinking about writing a blog post if I have enough time, which is another issue that I'm dealing with right now.
Mhm.
All right, so that was a very lengthy introduction, but I think it was very helpful to many people, at least so that they understand like what are the current contemporary challenges we're dealing with. Um, what else, Alicia, we can share in terms of the updates? Well, I can think of the update requirement for super visa. So earlier, only the income of the of the sponsor of the Canadian child or grandchild was taken into account, and it was based on the last year income. But now they take 2 last years, and they also say like if your income doesn't qualify, we may take into account the income of the parent who comes to Canada. So that technically relaxes the requirements for those who apply for super visa. But again, do you think the income is the bigger problem with the super visa? I think No. Like, based on my experience, they always try to find reasons to refuse, not based on income, but on temporary intent, which is a huge challenge, especially if your application is being pre-scanned by Chinook system and flagged for the officer for, I don't know, manual review or whatever they flag it for. But I have had several applications for super visa where they just were cruel. They're like, you're not going back. But how do you prove that you go back if you plan to travel to Canada for 5 years and stay with your child and maybe your grandchild? So many questions, not too many answers, unfortunately.
Yeah, and temporary intent, this is a wider issue that applies for every time anybody's coming on any sort of visitor visa, a super visa, or a regular visa, but especially a super visa because it's longer, a study permit, or a work permit. You always have to show temporary intent. What are your ties to your home country? What are the factors? What are the pull factors? So, what is keeping you connected to your home country, and what might be enticing you to stay, maybe stay without authorization in Canada? And so that's what officers are always looking at. And it's important that everybody deal with this head on and address it. And in some cases, just the circumstances of your life and your family and your economic situation will be such that it's going to be a very steep hill to climb for you ever to convince an officer that you would leave Canada. So it's something that you need to be very aware of when you're drafting your application. They're going to look at past refusals. They're going to look at has anybody in your family made a refugee claim or had misrepresentation allegation finding against them. They're going to look at a number of things when they look at temporary intent.
Yep. All right. Perfect. So at this stage, we're 33 minutes in, not taking into account 11 minutes that we were late for the live stream. So 22 minutes technically. I think it's a good time for us to move on to questions. Okay. And so I'll go through the questions as much as I can in the chronological order, but sometimes we'll skip the question if it's too specific or we just cannot get the point in the question. So the first one would be for you, Alicia, and let me just share the screen. Okay. So in the French version of Express Entry questionnaire, so statutory declaration question, one question is badly worded. Est-ce que tu déjà refusé
Est-ce
le
que
statut?
X a déjà refusé le
I'm
statut
sorry.
de réfugié?
I just can't.
Yeah, and so this is a good point that all of our forms are bilingual, and it is important sometimes to take a look at the English and the French translation. They try to make sure that it's a good translation and so that the sense of the question is preserved between the English and the French variations. However, you're correct. If you take a look, and there is a difference in the French version, and thank you for bringing this up. I'll go take a look. I don't have that question pulled up in front of me right now, but you're right. The English is quite clear if you read the entire question. And this is where I don't know about you, Igor, but when I talk to people who have looked at this question and answered it incorrectly, they stop reading after they see has been refused refugee status.
Mm-hmm.
And if you look at the whole length of the question, it doesn't just ask, have you been refused refugee status or permanent resident status? It also says, or a visa or a permit to Canada or to any other country. And so we can take a look at the French version as well. But if it's unclear with that French version, you're absolutely correct. This question is very, very broad. It's not, did you refuse status? It's, has IRCC or any other government ever refused you a visa or a permit or status? Ever. And there's no timeline on it. There's no within the last 10 years. It could be when you were a minor child. And I always tell this to my clients, go back and ask your parents, did you ever try to apply for a school trip where you were going to take a visa, have a visa, and go to a different country if a visa was required? And was that ever refused? Because literally, IRCC has refused people's applications and in some cases given a 5-year misrepresentation bar if you fail to disclose a visa refusal, even when you were a child. So Good
Yeah.
point. Be super careful, especially if the French version of this question is at all ambiguous.
Yeah. And Alicia, maybe what I'll do, I'll also try. I'm trying to bring up the screenshot from the actual express entry thing. So,
Mhm.
all right, it should be here. Um, what's the challenge? And sorry, I just quickly redacted the sensitive information. But what's the problem here is that people just read one question and then they read the second question and they get confused like how to answer those. And typically, you would just answer both questions the same way, right? Because um, have you been refused entry or visa or permit? It's pretty much the same as have you been refused a visitor or temporary resident visa um, to Canada or any other country, right? So,
Except
uh,
entry is even more broad. And
mhm,
so it's even worse, right? Because they didn't even have to refuse your permit or your visa. They could have just turned you around at a land border, and that's technically refused entry. And
mhm,
so this is sometimes what happened with clients who were in Canada. And back when they went and tried to do flag polling, sometimes what would happen is US authorities would actually not allow them entry, but they would give them a slip of paper, send them back to the Canadian side. And technically, that slip of paper is a refusal or a denial of entry to the US. And if you fail to disclose that in your express entry application, they can refuse you or bar you for 5 years for misrep. So be very careful.
mhm, yeah. All right, let's move on. So, Joe says hello. Hello to you, Joe. Snowy, snowy morning. Indeed. At least it is for Alicia, not for us. Hopefully, we don't
Can't
have
believe it's
snow
not
right now.
snowing there, Igor.
It's not yet. It's not. Well, I'm very glad. Let's see. I think someone also said hello. So LJD. Oh, Lou. Hello. Hello, Lou. Lou is another immigration lawyer, our very good friend. Very nice to see you, Lou, here. Um, we have another viewer saying hello, and then most of the other questions are just comments, are just questions. Okay, so we'll not be wasting any time. Um, I'll pull up the question from Rihan. So Rihan is asking, what are the basis for HNC application? And
Mhm.
it's
And,
it's it's a very
and
open question.
yeah, and Rahan, take a look. We've done a few things on agencies, and Igor did a good job on our website of outlining what are the factors that IRCC looks at based on the legislation and case law for humanitarian and compassionate applications. But here's the thing, here's the practical reality, and this is circling back to what Igor and I were talking about at the very beginning. 1,000 humanitarian and compassionate applications will get processed for 2026 and about the same number for 2027. And if you look at the backlog, I think, what are we like
50 years.
above? Yeah, like there are, what was it, 50,000 applications that are
Mm-hmm.
already in the queue, something
Yeah.
like that. So I cannot in any good conscience recommend that people file a humanitarian and compassionate application right now
Mm-hmm.
given that scenario, depending on your life factors. It would have to be pretty egregious, and you would have to have basically zero other options because your likelihood of getting a humanitarian and compassionate application approved is probably less than 1% right now.
And it's also interesting, Alicia. So if we have 50,000 applications and they say it's going to take them more than 50 years, and the approval rate is about 1,000 applications per year, so we essentially will presume that they will process 1,000 applications, right? If they do that, that's about 3 applications per day. So if we take 200 work days, that's about 5 applications per day. So how many officers they have allocated to process HNCs? If they say, okay, we're gonna approve 1,000, um, and then everyone else is gonna get refused. So let's assume the refusal rate will be 90%. Okay, so then we have like I don't know. So 500 applications per day. So, like, how many officers do they actually allocate to process these? You know, and so if they
Yeah.
know that this is a huge issue, like,
Yeah.
is it okay? Like, okay, so even if they process 500 applications per day, then how in the world did they project that it's going to take them 50 years to process 50,000 applications? Something doesn't sound right.
Because more people pile in every day, right? And so this is it. It's just like you cannot ever get through the backlog, which is why people are worried about about Bill C-12, because they're worried that they're just going to wipe out the entire agency inventory, and maybe have some sort of pool or some sort of lottery in order to be able to select from new agency applicants.
Yeah, but it's just like, this is the consequence of letting um, too many people in, and then promising them golden future, just come and study and work, and then you're gonna get your PR, and then dumping them all at once. And so we have so many people who fell out of status and decided to go in shadow. And if I'm not mistaken, yesterday I was just like reading stuff online, and I may not attest to the reliability of the source, but it said we have like 37,000 people who fell out of status in last year, and about 40% of those went in shadows, which is crazy, right?
Yeah, I mean, when Minister Diab was getting questioned, they did talk about figures on the study permits and how many study permit holders were trying to extend or change their status, and then how many follow-ups were happening with IRCC officers. And it seemed like the minister had said that many of those study permit app- applications, um, they made a subsequent application, right? So often students will try to extend or change conditions on a study permit. And often, if they know that they're not going to be able to have a pathway on their study permit, they might apply for PR. They might have applied for express entry. They might have learned French. So maybe
Mm-hmm.
they also transition to PR. So it's difficult to try to put too much stock in big numbers unless there's a deep dive in exactly what's happening with those applicants.
Mm-hmm. Yep. All right, let's continue on with questions. This one is good. Can you submit an upfront medical for Alberta rural renewal stream, even though RCC website says to wait for request, which is not the same way as it is with Express Entry. So what do
Mhm.
you think?
Can you? Yes. Um, there's not going to be any negative consequence if you submit an upfront medical, other than you have to pay for the panel physician and the upfront medical. It'll hopefully be on your file. So if you submit it with your application through your PR portal, then it'll all be together and they should be able to match it up with your file. And hopefully then when they take a look at your completeness check, they will notice that it's already there, and then they won't send you another MIL, a medical information letter. Could you also wait? Yes. And the reason that you might also wait is just because of the validity of the medical exam. So normally that medical exam will time out if it's been too long by the time the IRCC officer opens it up.
Mm-hmm.
So we know that PR portal applications are taking much longer to process than express entry applications. There's no 6-month service standard for PR portal applications. So normally you have to get that Alberta nomination. Then that nomination is going to expire. You have to submit your PR portal application before your nomination expires. And then it might be 1 or maybe up to 2 years before you're going to get a determination back from IRCC federally on your PR application.
And on this note, what you can do, like if you already have completed your medical exam, you still can submit it. Like nobody will punish you for that. And you can also
Mhm.
make reference to that special public policy that extends the validity of your medical exam to 5 years. And you may say, well, look, I meet all of the requirements. I'm in Canada. I've completed my medical exam within the last 5 years. I'm applying for temporary or permanent residence. And then my medical report doesn't show that I pose any uh, risk to public health and safety. And so here's a copy of my previous immigration exam. If you find that acceptable, just please accept it. If not, I'm happy to do another one upon your request. That's how you would normally do it. And maybe it will save you another $500. Okay.
But they might also ask you for an
Yeah,
updated medical.
exactly. I remember when I was immigrating back in, like, when I submitted my application in 2019, we had medical exams, and like, it's just so stressful because you think, okay, like, if if my wife's gonna get pregnant, for example, will she be allowed to do an X-ray, the chest X-ray, right? Typically not, right? And so, will that affect my application? Well, of course it will, right? Then at the same time, like, we've submitted the medical exam, like, okay, everything was just fine for us. Then it got expired. And I'm like, okay, we're gonna get another request for another medical exam. And Alicia, that was like at time of COVID. Like, COVID was a real
Mm-hmm.
thing by that time. And so we were all panicked, you know, and we had some other challenges with our legal status in the US and stuff. And it's just like, just one tiny thing, one tiny aspect of your application may um, can essentially let you go, you know, crazy, because like you lose your sleep, you think about what's going to happen. And so for those
Yeah.
people who have those medicals, just submit it and make a pitch, you know, and if it works, then the officer will accept. If not, they will just send you another request.
Yeah, and I think, Igor, it's a good point about how stressful those medical exams are and also how they can affect your application. So I wonder, maybe we should do a podcast episode on medical exams for express entry, and also what to do if you do have a medical condition, right? What is a serious physical or mental disorder? And I have a lot of consults about this, and you never want to be in a situation where you fail to disclose information that IRCC says is material and relevant, and they come back and say, hey, you didn't disclose this sort of medical condition. We wanted our panel physician to be able to have the chance to assess it for excessive demand or public health and safety. Usually it's excessive demand. And you could be barred for 5 years for misrep if you fail to disclose something, even if you don't think it's a serious medical condition, but maybe IRCC does. So this is something where you do have to be super careful if you have chronic conditions, if you have kids who have ADHD or autism or diabetes. All of these things are conditions that ought to be disclosed to IRCC.
And it becomes even more relevant, especially if you have a non-accompanying family member, like a child who has a medical
Mhm.
condition and that child is inadmissible. And
Mhm.
then all of a sudden, you may be inadmissible as well for permanent residence,
That's right. Yeah.
which many people just don't realize until it's too late, or until the application is already submitted and they got the request for additional information after their medical. So,
Yeah.
absolutely a very good idea to do an episode on this topic. All right, let's see. So we have a couple of questions about the startup visa. We pretty much shared everything that we know about it already. It's just unknown what's going to happen to it, whether they will reopen the new one or not. I see a comment from Henry. You guys didn't show up last week, and then face purple crying. We didn't. We didn't. And we had a very special occasion. So Mark was traveling to Calgary because um, we had a newborn and we decided to baptize our son. And so Mark was our godfather. So, like, our typical schedule with Wednesday live streams just was disrupted for that 1 week, um, for a very happy occasion. So everything went just well, and yeah, this week Mark is also not available, but luckily Alicia and I can do the live stream today. All right. Next question is from Brian. So, is the expiration date on the language test is locked in at the time of submitting the PNP non-express entry application to RCC, or is it locked in after the acknowledgement of receipt? Given
That's a
that
good
it takes
question.
about a year to get an acknowledgement
Eight
of receipt.
months to a year right now to get an AOR. That's a good question, Brian. And I would have to go take a look on IRCC's policy on lock-in dates. So they do have it in their operational guidelines, but I haven't looked at the language test for a PR portal application in terms of what date they're going to use on that. So that is a really good question. So
But at least I just
I
cannot
will.
see any world where the language test would not be locked in at the time when you hit the submit button, because this would be procedurally unfair. Like, what if it takes them 5 years to issue the AUR? Does it mean that you need to complete another three language tests before they issue the AUR? So I would say likely it is at the time of submitting the application. At least I do not see any other chance that it would be something else. But again,
Yeah, those
knowing the crazy world we call immigration, anything is possible right now. So, all
the
right.
processing times are through the roof.
All right. So let's have this question. So CC applicant worked remotely from my home country for 9 weeks. Added it as a separate entry for continuity, not claiming points. Is that okay, or should I move it to personal history after ITA?
Yeah, and so Rohan, anything, so Igor and I are both immigration lawyers. We have this live stream with Mark in order to try to provide really high quality immigration information. But we never ever want to give immigration legal advice based on a couple lines of text. And so we would encourage you to reach out, book a consultation so we can really figure out exactly what's going on in your work history, where you're getting your claimed points, how is this going to affect you? Do you have an accompanying spouse? What's going on with your how you've written out your work history, your education history, everything. But in general, um, yes, you can put a period where I'm assuming you're working for your Canadian employer still, but I'm not sure. So I don't know if you're working for a foreign employer or your Canadian employer. So if you are not physically present in Canada, you ought not to claim 9 weeks of work as work in Canada. So you're correct on that. You ought to be able, usually, to be claiming it as foreign work experience as long as it's high skilled, you have the knock, you have letters from your employer, you've got your hours of work, and you can prove that it's 30 hours a week. It doesn't seem like you're claiming points for it. Um, as soon as you put anything in your work history, it will ask you for justification for that period of time. So it will calculate points for anything you put in your work history. And it might be relevant because you might be trying to get a certain, like hit a certain number in order to show your work experience. And depending on how long ago it was, you might be trying to combine it with other foreign work. So there's lots of things to consider, but as long as you are not trying to claim it for Canadian work when you're not physically present in Canada, that ought to be okay. But just know that if you put something in your work history section, they will ask you to justify it.
Mm-hmm. And another thing is how your reference letter is worded, because if it says Rohan worked for us from this date at this date at this location, then and if the reference letter doesn't mention that you worked some period of time overseas, then the officer may question, okay, how accurate this letter is, right? And so why did you break it down in your in your personal history or work history, but the letter doesn't talk about it at all? Um, and so um, otherwise, like if you didn't do your due diligence and you weren't attentive enough and you just put it as one entry, would it amount to misrepresentation? And I think it very well may, right? So it's important to look at what was submitted exactly before we can tell you.
Yeah, super good point, Igor. So, exactly. If your Canadian employer is writing you a letter of reference and 9 weeks of that you were still working for the Canadian employer, but you were working overseas remotely in your home country, they should definitely mention that in their letter.
Mm-hmm. Mm-hmm. And I think we have another related question. Um, so it also deals with work experience. So it was an FSW candidate, healthcare ITA, received on 20th of February with 2 years and 11 months. So the EAPR was submitted 2 weeks after the ITA without hitting exactly 3 years for the 50 foreign work experience points. So should this person, Evany, Batty, be worried? Do you think they should? I think they should, and I'm gonna hit this button and again, it leads you to the consultation, where we can look at things. But long story short, Alicia, how do they calculate that work experience? So the hours,
Mhm.
the days, the weeks, the months, what do they look at?
Yeah, so this is the problem. The system only asks you for the month of work. And let's say you started working on, I don't know, April 30th. It will give you credit for the entire month of April, even though you only worked one day in the month of April.
Mm-hmm.
And that, they say, is your problem, not their problem. So they say if the system gives you an invitation to apply too early, if they overcalculate your points before you've actually earned them, then it's up to you to take a look at what was the point threshold that you legitimately had in your Express Entry profile and your CRS score. And also, because you're an FSW client, this can also affect your minimum eligibility under your selection grid factor points of whether you're hitting your 67 pass mark. And so there are two really big things to be worried about. And also, if you've proceeded with an invitation to apply when you actually weren't qualified, you're losing a whole bunch of processing time, right? So, one, you have a risk of refusal, you're losing processing time. And two, you have a risk of misrepresentation if immigration thinks, oh, well, you tried to game the system or take advantage of the system, even though you knew you ought not to have been qualified, depending on how you've structured your application. So, there are a number of things we would definitely want to take a look at with you in this scenario.
Mm-hmm. Um, all right. And I think I also saw somewhere in the instructions, program delivery instructions, that they say basically we will assess the timelines on a case specific basis. So it is entirely with the officer to make a final decision. Yes, the system may give you extra points, but ultimately the officer will decide if you qualified for those points. And another thing I see, Alicia, all the time is um, the system would give you points for work experience before you hit even like 11 months of work experience. If the system calculates that you accumulated 1,560 hours of work experience faster. I remember I had a client, um, I think she was eligible for a CEC, but she wanted to qualify under an educational category. And so she had some probably like 5 months of work experience as an early childhood educator. And so we had to go and create a table where we essentially listed every single day that she worked and the number of hours
Yeah.
she worked. And then she was like, I don't know, 40 hours short. And we just couldn't proceed with that application. Um,
Yeah,
and
and this
40,
this is
40
a
hours in a
real
couple of
risk.
days.
Yeah, this is a real risk with educators or teachers where you have sometimes they're not paid during the summer or they're laid off during the summer, but then they put that as one block of work. Or if you have workers in unique circumstances where you're paid for, 3 weeks on and 1 week off, or 2 weeks on and 2 weeks off. So, yes, it's super important to figure out what are those actual hours of work, and it's up to you not to claim them until you can prove them.
Mm-hmm, mm-hmm. All right, so let's pull up the question from Joe. So, if one expects an ITA in the next month, is it necessary to start requesting police clearances even if you did not leave Canada at all? Upfront medical. So, it depends on what police certificates you want to request and what police certificates you need, right? A good example is Qatar, which takes like 3 to 4 months. Um, should you request them like if you expect an ITA in the next month? Absolutely. Because it's just going to take forever to get those. Some police certificates are just not needed. For example, Mexico, you do not need a police certificate. Or, if I'm not mistaken, um, Colombia doesn't ask for one. Uh,
You're talking about upfront.
Upfront, yeah. Like you just need to wait for them to send you a request. You take that request and then you apply for the police certificate. For some countries, like in Canada, you do not need to apply for a police certificate at all, right? So it really depends on what country you're dealing with. Anything else to add here, Alicia?
Um, Igor's right. It depends on which countries. Um, I I tend to have quite a bit of anxiety with police certificates and marriage certificates because every country does them differently,
Hmm.
and there's a significant risk that people mess up how they obtain them. Like if you're looking at certain jurisdictions within Australia, you've got to get the abstract for your driving history report in addition to your federal police check. So read those instructions very, very carefully. Make sure you are always providing your color copy of that original police certificate. If it's not in English or French, then you also need a certified translation that is in English or French, but you always also have to provide the original before it has stamps and seals all over it. So yeah, make sure that you're careful with police certificates.
Hmm. We got a super chat. Um, and then the question. So, hi, I noticed something confusing in my PR tracker. When I checked the JSON data, which I think is technical information on the page, it shows that the Cooper was issued, but on the main tracker page, my status is in background, in progress, and eligibility not started. Um, I don't know how to answer this question other than you just need to check your email and see if you receive any communication from RCC, and then whatever information is reflected in your PR portal, um, in your IRCC secure account, let's say if you submitted an express entry application, that is the information that's relevant. IRCC has not did not design their system for people to go and check the technical code um, on their pages to learn about their status. So it may be just one of the things that's I don't know. I don't know how to explain from a technical standpoint, but maybe that's just part of their JSON code, whatever. Sorry, I'm not a tech wizard. Maybe I am, but only to a certain extent. Um, so, Mohammed, unless your RCC secure account shows that okay, the final decision has been made, and please check the messages below, then that means that your application is still in process. What you can do, you can submit a native request and check exactly what's going on with your application, or what was going on with your application given the delay um, in getting those two CMS notes. But right now, I don't think you have to worry.
Mhm.
All right, let's return back to the questions. Oh, okay, this one is interesting. So, applied for LMA based work permit on 27th of August from Pakistan. RCC website shows 7 weeks of processing when I applied, but now it's showing 29 weeks. Which one applies to me?
Hopefully the 7 weeks because they bounce up and down. So normally if you, and this is a good reason why you should take a little screenshot of what the processing times are when you submit your application. But that said, they're not going to be held to it. So if something changes or world events happen and they change where officers are located, all sorts of things happen with respect to processing. And so it might be that that processing period goes shooting up and it becomes much longer than you had anticipated. Um, but again, there's not really a good way of knowing. Sometimes, if you take a look at the IRCC processing tool now, it sometimes asks you, have you already submitted this application? If so, when? And then you can give it a date range. Did you do that in this
Yeah,
case,
but
Igor?
not for the work permit applications, Alicia.
Yeah. So, um, we don't know.
Yeah, yeah.
Yeah.
I would say that they want to keep those processing times flexible and open, uh, so that they may change their priorities if needed. Um, Again, geopolitical situation may also affect how officers work and what their processing capacity is. Um,
Yeah.
so
And,
what
and
I'm what
Igor,
I'm
just on that,
oh, go ahead.
oh, sorry, you can finish up and then I was just going to answer. There's another LMIA question too.
Yeah, what I'm thinking about, Alicia, though, with this question is that if the application was submitted in August of 2025, when the processing time was 7 weeks, and there's no decision yet on it, um, what what I'm concerned with is maybe they're searching for something. Maybe they're putting your application in comprehensive review. Like they need to do some extra checks. And so that raises questions, okay, was everything properly submitted? Was the information accurate, true? Are they investigating potential misrep? Are there any security concerns? Did they send your file for security screening and so on? And the only way to know about it is by requesting the GCMS notes, um, and then seeing exactly what's causing the delay.
Yeah. And then Igor, I wanted to pull up Jay Arbutamata, who is asking about another high wage LMIA. And so it's really important that anybody who's in Canada who's on an open postgrad work permit that's about to expire, if you have an employer who's gone through and has done the advertising and recruiting and submitted an LMIA application, and it's a real LMIA application, we're not talking about a dummy PGWP extension, but the employer actually submitted this LMIA application, you have an LMIA file number specifically, and you've got proof of submission. So yes, your daughter should absolutely make sure that if she's going to stay in Canada, that she submits an application to change conditions, extend her stay as a worker with proof of that specific LMIA file number and proof that it was actually submitted and that processing fees were paid, and ask that IRCC wait for ESDC to make a decision on that LMIA before making a determination on her work permit. Now, um, it can become complicated depending on how the employer applied for that LMIA. So if they did an application on the LMIA to support permanent residents, they are probably not getting a decision back for a year. If they did a regular high wage or maybe well, it's not going to be a dentist, is not going to be GTS. So they probably hopefully just did a regular LMIA high wage, not one to support PR. And that hopefully has a chance of coming back within maybe 4 or 5 months. But it depends on what stream they picked. So that's important to keep in mind as well.
Mm-hmm. Okay. Good question from this viewer. So, got a bridge and open work permit. My PNP in Alberta was submitted before the implementation of expression of interest stream. And so, long story short, the application was submitted in 2024. Can I change employer and occupation with the AAP? And the short answer is, let me just find the right button. Can I, should I, is it permitted in my personal situation? Those questions we answer in immigration consultations. But in general, Alicia, are there risks with changing occupations or even employers if you continue working even in the same NOC code?
Mm-hmm. Yeah, and so it really depends on your stream. And you said via T and H streams. I'm trying to figure out
Tourism and
what you mean.
hospitality.
Oh, the tourism and hospitality. Oh, yeah, yeah. So tourism and hospitality is 100% dependent on your employer, right?
Mm-hmm.
Because your employer has to be on the list. They have to meet certain conditions in order to be eligible to support somebody's nomination under the tourism and hospitality stream. So without knowing more, I would say it's definitely a risk um, if you change employers, because as soon as you change employers, you have an obligation to notify AAIP about a material change in circumstance. And that probably is going to trigger a bunch of questions. And you've got to go back to your basic eligibility to see if your new employer is going to meet eligibility under the tourism and hospitality stream as well.
And one of the things is for tourism and hospitality stream, you need an employer specific uh, LMA supported work permit,
Mm-hmm.
which is a very big issue, right? So in general, we would say you want to keep your employment with your current employer all the way until you become permanent resident, which is a huge issue, right? Like especially if, let's say, it takes the province about like I don't know 6 to 7 to 8 to 9 months to get the nomination, and then it takes another 2 years for the IRCC to process the application. Essentially, you're locked in, and it creates a very big risk for the employer to abuse the employee, and again, it suspends your family plans if you want to have a child, let's say, and your spouse is the applicant, and she cannot go on mat leave, and all sorts of crazy things happen. The next question is from Misser. Um, Can an approved permanent resident visit another country just before their first entry or landing in Canada as a permanent resident, or will that be an issue? Well, first of all, before we answer the question, you're not a permanent resident until you complete that landing. So um, that's a slight correction before we go into details. But Alicia, do you know of any restrictions on visiting other countries before you do your first landing?
So you'll want to be careful. Um, did you do an inside Canada or an outside Canada type of application, right? So if you did an express entry application, for example, and you put that you had been living in Canada and then you took a trip, but you didn't notify IRCC of a change of address, that can be a big issue, right? Because they might be doing an e-COPR landing process and not know that you're outside of the country. Let's say you did an express entry application, maybe you speak French, you got an invitation to apply under a francophone draw, and it was always outside of Canada, and you got that approval letter. It sounds like that's what you're talking about. You got the approval and principal letter. They say, okay, send us your passport because we've got to put in your counterfoil for landing. Um, Maybe that's what you're talking about. And if that's what you're talking about, Igor is 100% correct. You do not actually become a Canadian permanent resident until you actually get to the Canadian port of entry, usually an international airport, and the officer asks you questions. They sign everything, you sign everything, and then you have that valid COPR, confirmation of permanent residence. And until that happens, you're not actually a Canadian PR. So that letter and the request for your passport for a counterfoil isn't a full approval. So you are not a Canadian until you actually have that signed confirmation of permanent residence. So you would want to be careful about travel because you're just traveling on your foreign passport.
Mm-hmm. This question is really good. Can we re enter Canada after traveling to the United States with a valid TRV, but I have a valid open work permit, TRV in process since without having a valid TRV, but I have a valid open work permit, TRV is in process since December 2025. Do you know the question? Like the answer?
Again, again, we are not going to touch this with a 10-foot pole unless we had way more information. But first of all, um, you can never enter the US unless you also have authorization and a visa to enter the US if your visa required. So full stop. So there are no flag polling. You can't just run down to the border and come back, especially now. You're basically asking to be detained in the US if you're not super careful and you don't have your US visa. And we are not US immigration attorneys, but definitely go talk to a US immigration attorney about what is required and what the risks are in that circumstance. If you're asking about the Canadian side of things and you are visa required, so let's say you require a visa in order to re-enter Canada, it is a problem if you don't have a visa in order to re-enter Canada. So you always have to have a valid passport. Your work permit is your authorization to work in Canada and remain in Canada. But as soon as you leave, and if you have a visa requirement for your country of nationality, you need a visa that's valid in order to be able to re-enter.
But there's a caveat, which is the contiguous territory rule, and we'll not
Yeah.
be diving into details here in this live stream. But there are some circumstances where you may travel to the US and return back to Canada, to the US and St. Pierre Miquelon, which is like this very tiny part of European Union right next to Canadian border.
Newfoundland. Yeah.
uh, and like there are some circumstances where you can travel to those territories or country and then return back. But certain conditions must be met. So absolutely, we would hit the triangle button, invite you to book a consult with us, and then we can talk. Miss Marita saying, okay, hi Igor and Alicia, hello. I just wanted to thank you for doing these lives. They're very helpful. Watching from Sault Ste. Marie in Ontario. Thank you so much. Thank you. And Rihan is also thank you for your honest guidance. Well, this is exactly why we do these live streams because it makes us feel good. And we love receiving those thank yous, and we love helping you people as well. Okay, so this question from another viewer. I'm not going to be trying to pronounce the handle, but if I get TRP for 3 years straight, can I get permanent residence automatically? Short answer, no, you can't, because it has to be 5 years.
It depends on the type of TRP. And it also depends on whether it's continuous with no breaks. And so there are specific rules under the Immigration Refugee Protection Regulations and the Act that talk about continuous TRP holders and the ability to apply for PR. It is a different period of time if it's medical inadmissibility, criminal inadmissibility, a different type of inadmissibility. So it depends. But most of the time, it is very difficult to have continuous TRP status. There's usually a break in TRP status, which resets the clock. So that's the thing to be aware of. And then you don't get it automatically. You literally have to file an application for PR and prove that you meet the statutory requirements.
And the other thing is the TRP, each subsequent TRP must be issued for the same inadmissibility reason.
Right.
So if circumstances change and you overcome your inadmissibility somehow, then and you have another reason for requesting a TRP, then it basically restarts the process.
Right.
All right. Okay, so this one, before I even read it out loud, there's a triangle. Is it okay to accept an audit interview from Service Canada? This is from a temporary foreign worker program.
So .com, I'm not sure if you're an employer or if you're an employee. So ESDC, Service Canada, has broad powers to do audits or employer compliance inspections. And they will do that if the company is going through a temporary foreign worker process, they've filed an LMIA, or they have filed an LMIA anytime within the last 6 years. They can go and do an audit or an inspection. Same thing if you had an employer-specific work permit under the International Mobility Program. So they have very similar powers in both cases. They can access the place of work, they can search electronic records, they can go interview people. So in general, it is a requirement to comply with the request of an officer and to provide them the information that they are looking for. Um, you can take a look at the list of non-compliant employers, and one of the reasons for non-compliance could be failing to respond to or comply with a request of an officer for reasonable information. So
Mm-hmm. All right. Next question from Joshua. My postgrad work permit was refused based on getting 6 in the reading module, but I had 7 in reading modules in different setting. Can I combine 2 self-pip test results to apply for reconsideration? No, you
do you want
can't.
to answer this one, Igor?
No. So reconsideration is only effective if there was a clear mistake made by the officer, and you just point that out and you say, "This is clear mistake. Please reconsider. Alternatively, we may consider other options, essentially going to federal courts and trying to overturn it." Um, Obviously, you don't want to threaten the officer, but you want to at least make it clear why you're asking for reconsideration. And it's not just because you improved your language score. Ultimately, what matters is what was submitted with the initial application. Were you eligible or you were not? And if you were not eligible, then the officer was correct in refusing the application, which now creates a whole sorts of problems for you, Joshua. Can you reapply again? Can you restore? If you can't restore, like what's the process of restoring and to what status? When did you complete your studies? How long did it take them to refuse the application, and so on and so on. So in these situations, we would want to speak with you privately and then discuss probably your situation in more detail. So book a consult. And again, for those who are wondering, like you always say book a consult, but how do I do it? So all you need to do is you go to our website, which is holthelaw.com, and then you can click this button on this button, whatever you like better. It takes you to the same page. And then when you scroll to those 3 beautiful people out here, you can select the duration of the consult. It's either 25-minute or 50-minute consult. And then we may then connect with you over Zoom and we'll have a screen share session where we will look at the relevant provisions, documents, and so on and so on, trying to answer your question. All right, let's see. There is a question from Riyadh. Good morning, federal skilled worker application. It's been 100 days since the acknowledgement of receipt, and I haven't received my biometrics instruction letter. I just got my GCMS notes, and they show that biometric status is cancelled. Error assessment required. So what do I do, right? Let's see. Oh, and then there's a follow-up. So while in my country they're issuing biometrics from March, my application has been stuck since December. IRCC call center agents can help. They only see limited information. Do you suggest escalating the case with the local visa office?
Yeah, I mean, you can try putting in a web form, right? And just
Mhm,
say, look, this is what I noticed and lay it all out in a web form inquiry, basically, and just say, this is what's going on. I'm concerned that I haven't received my BIL. And when I do the notes, it says that it's been canceled. So I'm concerned about that. Can you please reissue the biometrics instruction letter so that I can go get that done? Keep a copy of everything you put in that web form request, a screenshot of what you've done,
mhm,
and then hopefully you'll get that automatic response back with a copy of what you had submitted to them. But you want to keep evidence of all that, basically
okay.
just showing that you're doing everything you can to follow up.
Mhm. There is a comment from Vancouver boy. Sorry, I was waiting for you, waiting, and you skipped my question. That wasn't very nice. Mark wouldn't do that. Maybe Mark wouldn't, but we've talked about the Bill C12 in great depth at the beginning of the live stream. So we just want to make sure that everyone gets the chance to have their questions answered. So I'm traveling to the US with proper visa, and to come back to Canada, I don't have a TRV, but I have a valid work permit. I think that's pretty much the same question that we've got from another viewer. Can I go there and come back in this situation? That really depends. For how long did you travel to the US? Or are you planning to travel to the US? Are you planning to exit the US? Um, the validity of your work permit, etc. One thing to remember is that every time you cross the border to Canada, you need to show that you are temporary, you have temporary intent, and you a genuine temporary resident, that you will leave Canada at the end of your authorized stay. And so, um, even if you get a chance to speak to an officer on the Canadian side of the border, there might be a ton of questions, and it also really depends um, uh, on where you travel, whether that's the airport, whether that's Scoots or somewhere else, right? Like, and border officers, they can be really mean in certain locations. We actually had a client, Alicia, and I'm meeting with a client later today. Um, the border officers, it was an American citizen, and so he was traveling to Canada. The border officers gave him like a really hard time before his entry, and they said, well, okay, we're going to give you a visitor record which matches to 6 months of since the date when you enter, which to me doesn't make any sense. Like, why would you give a visitor record for the same duration of authorized entry? And then they said, if you don't submit an extension application while you're in Canada, we will not let you in again. And I'm like, what? Like, what's going on? And so we're like, okay, you want an extension application? We're gonna do that. You know, it's like it's only $100, so not a problem. We're gonna show you proof that we complied with your request, which is like sometimes like I don't get it, and yeah, that happens. All right, so I see that we have a ton of questions. We have only 5 minutes left, so we'll try to get through as many of those as possible. But for those people who submitted their questions and it's not answered, you don't have to take that personally. We just don't have capacity to go through all of them. We try our best. Um, okay, if applying under CC from outside Canada, is a police certificate needed for RCMP? No. You just go to the website where it talks about police certificates and how to get one and who needs one. and where to apply for one, and then it will give you a drop down with countries. And when you select Canada, it basically says you do not need one from Canada. We'll request it on your behalf.
And they could request one, right? So
Yeah.
during processing, they could say,
Mm-hmm.
we want one.
Mm-hmm. Um, all right. Which PR program allows us to use part-time hours worked during our on our study permit? This is a question with caveat. If you're talking
Mhm.
about work experience obtained while you're a full-time student, then there is no program that allows you to use that work
Well,
experience.
not Canadian work experience.
Canadian, yeah, yeah. And
Right.
we're talking about Canadian because of the study permit. But if you were a part-time student or um, yeah, part-time student, yes, you can. But again,
Or if you're claiming foreign work experience.
foreign work experience, yes, as well. So um, depends on what experience you have, right? Let's see. What is Schedule A form and why would they ask for it after 4 months of an express entry application? Uh-oh.
Uh-oh.
Alicia, maybe you can explain what the problem is.
Okay, bad. This is bad news. So Schedule A 5669 is a background declaration form. And basically, they think something's wrong with your application and they want you to give them all the information so that they can refuse your application or say that you've misrepresented, usually. So something has caused them enough concern in the way that you submitted your express entry application that they are worried that you are lying to them or not telling the truth, or there are discrepancies in your application, especially when they're cross-referencing it with probably previous applications. So if you had study permits or visitor visas or postgrad work permits or other permits in the past, they're going to be taking a look at all of those applications and cross-referencing what you put in your express entry application and maybe your spouse's express entry application or your spouse's study permit where you were an accompanying spouse under an open spousal work permit. There's a whole bunch that they will look at. And so this is normally a sign that they have concern about your application, and you are going to want to go through your express entry profile with a fine tooth comb and take a look at all your other applications and try to figure out what have you missed, what's causing them concern.
Yeah. All right. Brian Lee says, my manager and HR refused to provide a reference letter. Can I prove my employment with other documents and have the original job ad? Will a self-declared affidavit notarized by lawyer work? Uh, many questions arise with this comment. Well, first of all, why they would not provide you with a reference letter? Was this work experience genuine and legit? Was it paid work experience? How you were paid? Maybe they concerned about the mode of payment. Some employers just don't file taxes, for example, right? And that's a big issue with some countries. They just afraid to go out of the shadow, and come clean and say yes, he actually worked for us. But then, will a self-declared affidavit notarized by a lawyer work? Alicia, can you answer this question?
Yeah, so Brian, take a look at our Express Entry Accelerator course. So we have an entire section on what to do when you can't get exactly what IRCC normally requests for letters of support from your employer. Uh, Keep in mind that it's always a risk. There's always a risk your application can get refused if you're not providing IRCC 100% with what exactly they've asked for, letter from your employer on company letterhead, your job duties, lead statement, making sure that it's aligning with the NOC, as well as the majority or a substantial number of the bullet pointed duties, your wage, your salary plus benefits, and the direct contact information for your HR manager or direct supervisor. Sounds like you're a doctor. I'm assuming that's what you mean by MD. Sounds like your employer was a doctor. I don't know if your work was in Canada or if it was in another country. So, depending on where you were, there might be other ways to try to get information to try to show that you were working as a doctor, but you're always going to have a harder evidentiary burden if you cannot properly provide what is Igor's got up on the screen here, which is what is in the program manual in terms of the completeness check that IRCC officers use when they're assessing an application under Express Entry.
Mm-hmm. And what I notice, is that it says mandatory documents, and it basically gives the only one option: reference or experience letter from the employer. And then if
Mhm.
you're self-employed, then you can provide a whole bunch of other proof, right? Because you cannot self-declare duties, or affidavits are not acceptable if proof of self-employment work experience. And so the same, um, by analogy, applies to your work experience for the employment period. And the reference letter is needed. But then when you are unable to prove all of the elements here, then you can use supporting documents like other evidence to fill the gaps.
Yeah, and Brian, you also said that your employer, and so one thing is if you are a medical doctor and you've been working in Canada, but you're technically self-employed, there's a whole bunch of other things that you need to be aware of. So take a look. I wrote a blog article on mistakes that doctors make in express entry applications. So getting that employment relationship, if you're an independent contractor, self-employed versus an employee, that's super important as well. So.
Mm-hmm. Yep. Rohan asks, should we show a 2 week home country, um, foreign vacation, and personal history? In other words, should we disclose the 2 week vacation that we took in Express Entry, I assume?
Yeah. So this is why Igor and Mark and I never just review one tiny little aspect of an Express Entry profile. We always want to work with you from beginning to end to look at everything and how it affects everything else. So, do you have to disclose your travel history? Yes. Do you have to disclose your address history? Yes. You have to disclose your work history and your education history and your personal history? Yes, yes, yes. So all those things need to make sense together. And sometimes it is confusing to be able to fit your life in the tiny little boxes that they give you. And that's why you have your letters of explanation. So it is important that all relevant information is properly disclosed because it could affect other things. Um, how you do that depends upon the unique circumstances of how you've structured your application.
Mm-hmm. Yep. I think we have two questions submitted by the same person because they sound pretty much the same. So people who have an average monthly income outside of Canada around 15K, how they can relocate to Canada, and pretty much the same is asked here, but from a Centaurus Academy. Um,
Mhm.
so I would presume that that's your question as well. So long story short, your income may be relevant when you choose the program for relocating to Canada, right? Um, Ultimately, your chances to relocate to Canada depend on your human capital, um, like your age, your education, your work experience, your language skills, and so on. And there are some programs that allow you to become permanent resident in Canada without ever setting foot in Canada prior to landing as a permanent resident. That's how we immigrated with my wife, right? Federal Skilled Worker Program. There are some programs that require that you obtain 1 year of Canadian skilled work experience. There are some programs that base your eligibility based on whether you worked or studied in a province. There are some programs that are family reunification programs, like if you have a spouse or a child in Canada or a parent. There are some situations where you may be already a Canadian citizen, you just don't know about it. So your income is just this very tiny piece of sand, grain of sand, in this huge sandbox of possible chances for you to come and stay in Canada. To know exactly which pathway would work for you, we need to know a lot more detail about you other than your income.
And and also it depends on what you mean by relocate to Canada, right?
Mm-hmm.
And so Canada has talked about this digital nomad program. And really all that is you're going to get a visitor visa. So you come to Canada, you come as a visitor, or if you're from a visa exempt country, maybe you don't need a visitor, you just come with an electronic travel authorization. And that's where, as a temporary resident, you can stay here as a visitor. You cannot work at all in Canada. You cannot enter the Canadian labor market. You have to show you're working for your foreign employer, you're paid in your foreign currency to your foreign bank account, you don't have Canadian clients. You might be able to just come and stay for periods of time as a visitor, as long as you can show you've got a way to support yourself without working in Canada. Is that going to lead you to permanent residence? No, unless you meet all the other things that Igor is talking about. But it depends on what you mean by relocate.
Yeah. All right. And we have three last questions before we drop off because we're 35 minutes in overtime. So I have 12 days left to complete my 180-day period after completing my studies. I have the opportunity to restore and reapply for postgrad within 12 days, but is the reconsideration advisable after passing my language test? Long story short, reconsideration request probably would not be advisable if you did not meet the eligibility criteria. For foreign experience, is reference letter and bank statement enough? I do not have pay stubs. Simple. They basically say for foreign work experience, all you need is reference letter. That's the only mandatory document. Everything else can be submitted in addition to the reference letter to make to provide other evidence of the genuine work experience that you obtained with that employer. The more evidence you have, the better. Not to suggest that you need to provide 1,000 page document to the officer, but it needs to make sense, right? And so um, it takes skill and practice, to be able to think like an officer. But you may predict, right? Like if I was the officer, would I be convinced by this letter? Does it meet all of the criteria that they put on their website? If it doesn't, what else would I want to see if I was the officer, right? And Alicia, one last question before we drop off. Is listing a student job in personal details history section mandatory if that period is covered by studies and was outside Canada? I'm not claiming points.
Yeah. Yeah, if you did it, then it's important that you list it in your personal history. It doesn't matter if you're not claiming point for it. The reason is it could be material to an IRCC's officer's determination of other things in your application. So you always want to list overlapping periods of activities. So if you are a part-time student and you're working, you got to list all of that. And so list the start date, list the end date, make sure that you've listed all overlapping activities because it could be relevant. And they can take a look at this in the context of previous applications as well. So be careful with that, but you never ever want to hide past periods of work.
Mm-hmm. Yeah. With your personal history section, you need to provide every single activity that you've done. Um, and they basically say it has to be for the last 10 years. But if you served for the government or you served in the military, there is no cutoff date. Like if you ever worked for the government or served, then even if it was like 40 years ago, you still need to provide
Yeah.
it. All right. So it was a long live Q&A. Obviously, we tried to go through as many questions as we could. Maybe some questions were not answered, so please accept our apology, but we're trying to do our best. And some questions are just too specific that we would just be essentially taking an opportunity from someone else by missing answering their question that was more generic and helpful to other viewers. But if your question wasn't answered and you still want to get an answer, as always, we will be back here again on Wednesday next week at 10 a.m. Mountain Daylight Time, just like we've been doing this for the last, whatever, 7, 8 years now. It's crazy. Like, I remember I joined the firm in 2020 and we had like 14,000 subscribers, maybe 13. And now we're like close to 70. Maybe we crossed 70. I don't know. I'll have to check. But thank you, everyone. Thank you, Alicia. And I wish everyone a very good and productive day.